Hello and welcome to today's webinar on the topics of beneficiary funds and trusts. This event is proudly brought to you by FAnews with support from two of the leading names in the South African beneficiary fund administration environment, Fairheads and Momentum Corporate. Over the next hour and a half, we will be entertaining you with three presentations on the topics of beneficiary fund products, standalone and umbrella trusts, and on the legal implications of divorce settlements and maintenance awards on retirement fund benefits. We will begin today's presentation with a talk by David Hurford, who is CEO of Fairheads Benefit Services, and he will be talking to you about the beneficiary fund product universe. Take it away, David.
Thank you, Gareth. Thank you very much, everybody. I hope you can all see my face, and I'm going to just share my screen. Hopefully the technology works for us today. So thank you very, very much, Gareth. Thank you for introducing me. And yes, I'm very excited to be part of FAnews' first live webinar. I'm going to talk to you a little bit about what I believe to be the best kept secret of the retirement fund industry, and that's beneficiary funds. I think it's one of those products that obviously is very well known in the sort of trustee space, but not necessarily outside of that. And certainly consumers are very, very limited in their knowledge of what beneficiary funds are and their benefits. So I'm going to jump straight in and chat a little bit about what a beneficiary fund is. So, you know, in the 1980s, in the sort of early days of death benefits, retirement fund death benefits that were due to minors were paid into trusts, and these trusts were largely unregulated, and they were they were registered obviously under the Property Trust Control Act, but the Master of the High Court had involvement there, and they were sort of quite prolific through the 80s and 90s. And then in the mid-2000s, some of you may recall the Fidentia scandal and the living hands frauds. And essentially what happened there was that a large number of minors' money was stolen. And we saw, you know, earlier this 2015 thereabouts, J. Arthur Brown finally being convicted and sent to prison for that, for his part that he played in that Fidentia scandal. But really that spurred on the regulator to establish a more robust framework for the protection of minors' benefits. And so beneficiary funds were born in 2009 to house these benefits. A beneficiary fund is a pension fund organization as defined in the Pension Fund Act, and it's regulated by FSCA, previously the FSB. And so the compliance requirements for a beneficiary fund are exactly the same as those for any other pension fund organization in the country. And so there's a significantly greater compliance framework around which they exist. So you'll all be aware that retirement benefits or retirement death benefits don't form part of a deceased member's estate. And so those benefits need to be distributed according to Section 37C of the Pension Fund Act. And it's one of the, in my view, one of the most complex pieces of the Pension Fund Act, because it places a huge burden on trustees to determine firstly, you know, what the level of dependency is on the deceased member, make sure that they distribute that benefit equitably, and then determine the mode of payment. That mode of payment can come through as a lump sum, as a trust if it's been nominated, as an annuity stream, and many of you would be familiar with the annuity type products that are available. But there's also the option of a beneficiary fund. Just to quickly touch on the taxation of death benefits that flow from retirement funds, the taxation framework exists around taxing the benefit in the hands of the deceased member. And so once that's occurred, obviously compulsory annuities outside of that, but once that's occurred, it becomes after-tax money. So if the trustees determine, and I'll touch on a little bit on why a trustee might determine that money should be paid into a beneficiary fund in a moment, but if a trustee determines that a beneficiary fund is to be used, why would they do that? I always make the point that a beneficiary fund is not a preservation vehicle. Its purpose is not to simply accumulate money in the beneficiary fund account until the child turns, he reaches the age of majority, and then they get a big lump sum at the end. Obviously, it can be used in those circumstances, in that way, if circumstances are correct for that. But the primary purpose is really to protect benefits for minors, so that their money is used in their best interests. So you can imagine large amounts of lump sums that get paid out to the child's guardian or their caregiver in a lot of instances in South Africa. How do you ensure that that money is used in the child's best interests? There's been a lot of press around in the recent past about RAF payments, and I think we're all conscious of some of that money that hasn't been used in the best interests of the person that it was supposed to help. So really, a beneficiary fund is there to protect that minor's benefit. And it's used to meet their education and other daily living expenses. There are some other benefits around the beneficiary fund. In particular, they're tax exempt in terms of both income and capital gains. And that's an incredibly useful aspect of beneficiary funds. Because the beneficiary fund is an umbrella organization, what you're essentially doing is also you're grouping a large number of beneficiaries together and being able to access institutional pricing that you wouldn't be able to access on a retail basis because of that scale. And beneficiary funds are not just for the retirement fund credit that gets paid out at the once a member of a retirement fund dies. It can receive any employment-related benefits, including the fund credit, obviously, any approved or unapproved group life. That was a change that was made in 2014 that allowed beneficiary funds to also receive unapproved group life. It can even receive accrued leave pay. So any benefit that accrues to the member on their death as part of their employment-related benefit can go into a beneficiary fund. And importantly, it can be used for both minors and majors. So although beneficiary funds were originally designed for the protection of benefits for minor beneficiaries, majors can also, with consent, use a beneficiary fund. So they can opt to put money into a beneficiary fund. So you can see how, because of some of the advantages of a beneficiary fund, there may be some benefit in actually using part of the allocated death benefit to a beneficiary fund for a major. So let's talk a little bit about why a trustee might use a beneficiary fund or select a beneficiary fund as the mode of payment. And this is really to do with, again, that protection. We've spoken a little bit about how, you need to ensure that the money that's being awarded to a minor is used for the purposes of their well-being. And so the trustees are expected to assess the parent or the legal guardian or the caregiver and determine whether or not they're going to be suitable to be able to handle the amount of money that's being paid out. And in a lot of cases, particularly in South Africa, where we faced with a large number of caregiver situations where there isn't a parent or a legal guardian, but it's somebody is looking after the child without having gone through a court process to attain legal guardianship of that child. It's particularly important in those circumstances to look at whether or not that caregiver is best placed to look after that money for that minor child. Some of the other things that need to be considered are around their financial position, particularly around their own credit position. You can imagine the pressure on people when they've got significant debts outstanding and they're awarded a large lump sum, albeit for somebody else, on behalf of somebody else. The temptation to use that to settle some of that debt and take some of that pressure it can be significant. So these are some of the things that a trustee must consider when determining whether to use a beneficiary fund. And these are the cases where it's not an option. The trustees have made that determination under their obligation under Section 37C to pay their money into a beneficiary fund. But of course, the beneficiary or the guardian or the recipient of the award may also elect to use a beneficiary fund because of some of the reasons I've spoken about already. So let's talk about what makes a good beneficiary fund. There are many to choose from, but really I think we've tried to boil down the essence of what makes a good beneficiary fund about these 4 things. That's really about doing administration properly. You really need to make sure that your admin processes are efficient, are good, your service standards are high, and that that you're not creating a burden for the family. The investment approach is also very key. Investing the money, we believe, is an important component of it, but it's not. It should be an independently managed process from the administration of the beneficiary fund, and then of course making yourself accessible to your membership and providing sound and clear communication. So it's really those 4 pillars that we believe make up a good beneficiary fund. So I'm going to take you through a little bit of a process around how Fairheads goes about setting up a beneficiary fund. This may not be the case with all beneficiary funds, but certainly this is how Fairheads approaches the establishment of a beneficiary fund. So for each member, call them a member, child, beneficiary, for each child there is a separately accounted for account. So think about it like a little bit like a bank account that gets opened for them with various allocations to different investments. It's really important for us to do very robust and strong compliance assessments. That's KYC, FICA, all of those processes to make sure that the fraud detection and prevention processes are in play. And there's a lot of time spent consulting with clients and making sure that they understand who you are, what you're about, how to access your services, what they can expect from you. It's absolutely key to set up that relationship, because in some cases you're going to have that relationship for 18 years. So set it up properly right from the beginning and make sure that all the expectations are very clear. In terms of how the beneficiary fund then works, it allows payments of 2 types of payments from the beneficiary fund. The first is the income payment. So most beneficiary funds will adopt an income policy in which they distribute income to the guardian or the caregiver, or in fact the major beneficiary if they wish, and they distribute an income on a monthly or quarterly or whatever frequency is required, so that it can so that the guardian can look after the sort of daily living needs of the member. It's not the purpose of this income distribution is not to pay out large amounts of money, but really just to meet the subsistence needs of the child. The amount can either be fixed by the retirement fund or the entity that's transferring the benefit, or it can be set at just simply 5% of the capital that's introduced and paid monthly. And it's loosely based on a living annuity drawdown rate. So you don't want to erode your capital from income drawdowns. There is a minimum that applies. Obviously, we try not to make payments which are very small to members, and so we've aligned the minimum amount that we pay to the child grant. But again, that can be changed should the guardian wish for that to be increased or decreased, in fact, or invested. The other method of payment out of the beneficiary fund is our capital payments, and those really are the focus of the business that we're involved in. And what this is really about is setting out or making payments to educational and other related expenses that the guardian might encounter during the course of bringing up the child. So it's very important that we set up and establish a notional budget for capital distributions. And so what we do at Fairheads is to determine right up front what amount we can pay per annum, so that they're escalating that by 10% each year, so that the member's left with some money at termination. And we usually aim for around about 30%, taking into account the income payments that we're going to pay and assuming an investment return and CPI. And so what we do is we communicate that early to the guardian, so that they can use that in their planning purposes to determine what level of school they can afford, those sorts of things. Now, it's not to say that they have to use that money, so it's a notional budget, and any money that they don't use of that annual budget will just simply be retained in the beneficiary fund and available for distribution later. Obviously, the majority, or around about 80% of the payments that beneficiary funds make, certainly of the beneficiary funds under our administration make, are for education-related purposes. So that being school fees, uniform, transport to and from school. There's, in fact, over the last 12 months or so, particularly with COVID, the increase in payments for data. Those are the sorts of things that we pay for under the capital distribution policy. And in the majority of cases, those payments are made directly to the provider of product or service. And so you can imagine the many thousands of claims. Think about it a bit like a medical aid claims payer, where that's the majority of the work that we do. And each of those capital claims is assessed individually to make sure that they're being used in the interest of the member, that there's no fraud, that the payments are going to the right people. The other side of the beneficiary fund is really about making sure that the child is progressing through their schooling, is in good care. And so we run every year a proof of existence. And then this is a bit of a misnomer, because I think it's a far bigger exercise than just proving that you exist. It's certainly far more than just a home affairs check to check that you're still alive. Obviously, we do need to confirm that the guardian is alive and that the member is alive and that the member is in their care. But it really is an information gathering exercise for us to ensure that there is that the child is progressing. And so we collect vast amounts of information through interview format with the guardian and the child to determine any inconsistencies or any indication where we may need to get some social workers involved to try and figure out what's going wrong. And so it's an incredibly important part of the beneficiary fund process. And then finally, you come to the point where it's about terminating the benefit to the member. And I think that the key part and what we've learned through the years of experience is that the earlier you start communicating with beneficiaries about the fact that they have a benefit and that it will be available to them when they turn 18 has really paid dividends. Because not only are they clearer about what they'll need when they turn 18 to get access to that benefit, a very large number of those people have actually started saying, well, we actually want to leave the benefit in the beneficiary fund whilst we finish our schooling and then on when we continue on with tertiary. And I think the reason for that, I think one of the stories I remember is if you ever win the lottery, one of the best pieces of advice you can be given is to put the money away, lock it away for 6 months, and then think about all the crazy things you're going to do with it. And by the time that 6 months is over, you've thought through all of that, you've actually given it some thought, and you use the money properly and wisely. And I think that same concept holds true with beneficiary funds. If you start communicating early with with these children, it gives them some hope for their future and gives them the ability to plan beyond just finishing matric. And so our experience is around 7 or 8% of the members in our beneficiary funds are there because they've chosen to leave their benefit in the beneficiary fund. If you can talk a little bit about the investment approach. Really, the investment approach is, because it's a pension fund organization, it does need to be Regulation 28 compliant. And it's loosely based on a life stage approach, which says we need to, for those with a longer term and a bigger benefit, we should give them exposure to a greater level of growth assets. And as they approach their their termination date or the maturity date, we essentially de-risk them as they go through. And we do that twice a year. So we effectively rebalance their investments twice a year so that they remain on their risk curve throughout. And obviously any requirements that they may have along the way, we would simply, we make sure that there's liquidity maintained so that we can meet those requirements. For us, it's an important component. Fairheads is not an investment manager, and we're simply an administrator of beneficiary funds. And so all the investments are outsourced to those that can do it better than us. Best of breed managers whose business it is to perform investment management functions. And then if I can talk just a little bit about the other important aspect, which is about communication and accessibility. What we've also discovered is that, you know, it's so important for members to be able to access our services. So we can have the greatest processes and systems. But if we can't be accessed by our membership, then really it doesn't help very much. And so you need to have a strategy around creating opportunity for your members and your guardians to access you, either physically through a branch network or through a multi-channel accessibility, contact centers which perform outbound calls. For example, in South Africa, we know that airtime it can be very expensive for people, and the number of people that contact our contact center and run out of airtime halfway through their conversation is significant. And so you need to have processes in place that you can actually then phone them back, or in fact, if it's going to be a long call, make sure that you're dealing it with on your airtime rather than on theirs. Developing strategies around walk-in centers, creating opportunity for them to be able to access your services through partnership distributions. And then most importantly, having field agents and guardian roadshows that move out into the countryside and visit the countryside so that people can actually come along and ask questions and hear about their beneficiary fund and any related information. And so I think hopefully I've given you a decent sense about what a beneficiary fund is and how they could be used. And I hope that it's been helpful for you to be able to hear some of this information. Thank you.
Thank you, David. Thanks for that informative presentation on the nuts and bolts of the beneficiary fund environment. I always find it quite fascinating how we still have in this day and age a struggle with proof of existence on beneficiary fund beneficiaries. David, are you still on, or have you already left the session? Because I do see we have one question here that you might like to address quickly.
Madly trying to find my mute button, Gareth, so I am still here, yes.
That's great. Sorry, I have diverged from the script a little bit. But the question comes from Madalitsu Alagu, who asks, if one sets up a beneficiary fund and the children are relocated to another country due to the guardian moving, how do the beneficiary funds handle the payments following that change?
So thanks for that. Thanks for that question. So I mean, from Fairheads Benefit Services, we look after about 100,000 kids, and probably about 10,000 of those live outside of the sort of South SADC countries. So we have a large number of beneficiaries. Unfortunately, we even have a couple in Australia, the poor beneficiaries that live in Australia, that we manage to pay on a monthly basis. So it really isn't a problem to make payments to them. Where we have situations where a guardian may be emigrating and leaving the country, obviously they can make application to the trustees to have that benefit paid out if it's appropriate to do so. So really, we take it on a case-by-case basis, and but certainly paying money to a beneficiary that lives in a foreign country is not an issue in this day and age. That answers the question.
Thanks, David. We actually have one more quickly, if you don't mind, and we'll make this the last one before we segue to the next presentation. Greg Smith asks, on an unapproved benefit, does the advisor or employer stay involved in the decision-making process, or is it just the guardian that you stay in contact with?
So I think that's a really good question. The issue that we have to deal with is to make sure at all times that we deal with we make decisions in the child's best interests. And so we will consult widely with whomever is involved in that child's care. Very often an independent advisor is involved and will provide advice through the guardian, and we will take that advice if it makes sense and is in the best interests of the member. Obviously, because it's an umbrella type of approach, the ability for advisors to select their own investments becomes slightly limited. But we would always welcome independent advisors that are providing information and advice to the guardian or the member. We would always welcome that.
Thanks so much, David. I think we'll end the Q&A, our mid-session Q&A there. I'd like to move along now to the second presentation of today's program. So thanks very much to David Hurford, CEO of Fairheads Benefit Services, for his informative talk. Moving on, I'd like to introduce you to Jeffrey Wiseman, who is the CEO of Momentum Trust. Jeffrey is going to add to the beneficiary fund discussion by throwing into the mix a discussion on trusts, and he will also share some of the considerations for when a financial planner or financial advisor might consider a standalone versus a umbrella trust. Jeffrey, you're up on stage now, please.
Thanks, Gareth. Good morning, everyone. It's good to be with you this morning to talk about trusts. And having listened to David talking about beneficiary funds and the role that they play, we often get asked questions, well, do umbrella trusts still have a role to play? And what are they really, and how do they relate to other trusts? So what I'm going to do now is to share my screen and really just to take you through a short presentation really that covers sort of financial planning routes, trusts, and beneficiary funds. And I suppose the starting point on a discussion regarding trusts has to be, really who are the role players to a trust, and really where do umbrella trusts fit into this particular picture? So if we look at definitions of trusts, it's really it's a legal arrangement where a person who's known as the trustee administers property separately from his own for the benefit of another, the beneficiary. And so we see those features common to all trusts. We have three main role players when it comes to trusts. We have a founder. That's the person who essentially decides that a trust needs to be set up, and he provides the initial funding to the trust, normally a nominal amount. In the case of an umbrella trust, it might be slightly different to that. You then have the trustee, who's the person who administers the assets, and it can be either in the form of what we would call an ownership trust, where the trustee owns the assets, or our South African concept, the Bewind Trust, where the beneficiary actually owns the assets and the trustee simply administers those assets then for the benefit of the beneficiary. And then we have the beneficiary, who's the person who's really entitled to benefit from the assets held in trust. So common to all trusts, you'll be able to identify, certainly in a South African context, you'll be able to identify somebody who acts as the founder, somebody who acts then as the trustee, and somebody for whose benefit the trust is created. You then have a further subset of trusts, which might be trusts that are discretionary in nature. And essentially what that means is that the trustee is given, or the trustees are given, the discretion to determine when and how benefits are to be paid to beneficiaries. Or you get something called a vesting trust, where the beneficiaries themselves have vested rights to benefits from the trust. And if we compare where we are now in relation to the discussion on umbrella trusts, it certainly makes sense that there would be some vesting of benefits. The trustee would hold these assets with a view specifically to providing regular maintenance and payments to the beneficiaries of trusts. And then trusts themselves may be created inter vivos. So in other words, the founder is living and it's created during a person's lifetime, or trust may be created in a person's will. So in those cases, even if we have a testamentary trust, we can go back and we can identify the founder being the testator, the trustee nominated in the will, and the beneficiary also identified in the will. So we have a common playing ground, really, as it were, for all trusts, and we then need to fit the different arrangements that we're exposed to into that particular framework. So what is an umbrella trust then? And you heard David talk about the living hands and fidentia situation that happened and the need for increased regulation. So there was obviously this need that was identified to create these single sort of trust environments to administer these retirement benefits. But obviously, there were opportunities for these trusts to be abused, as we saw with the Living Hands situation a number of years ago. But umbrella trusts themselves still have an important role to play in administering benefits, and hopefully through my presentation, I'll perhaps give you some guidelines in terms of how we see the use of umbrella trusts in conjunction with beneficiary funds and then also individual trusts. So an umbrella trust is registered with the Master of the High Court. It's regulated as all other trusts by the Trust Property Control Act. What is slightly different, though, is that we would register the Master Trust, which would then set out the important governance and related terms of the trust, and it will make provision for beneficiaries to become part of the trust in terms of underlying settlements that are paid into the trust to be administered for their benefit. And what we would then do normally is there would be a deed of settlement that would be completed in relation to each of those underlying settlements that will set out some of the items in which there is some level of flexibility that is granted to beneficiaries when establishing these individual settlements. When we look at beneficiary funds, what we find is a very strong regulatory framework through the Pension Funds Act that really sort of sets up how beneficiary funds need to be administered. And in the world of trusts, the trust deed itself is always key to governance. So your first port of call when looking at the administration of trusts is really to look at the trust deed itself and to look at the powers that are given to trustees in that deed. Obviously, it's subject to the Trust Property Control Act, but in general terms, the role of the trust deed is incredibly important in determining governance rules, for example, who the trustees are, what the minimum number of trustees are, whether the trust itself must be subject to an annual audit, etc., what policies and procedures and processes are put in place, and also some guidance in terms of how the trustees should approach the underlying investment of assets in the trust. So what we can see here is the regulatory shift away from this environment where a lot of power and control was given to the individual administrator or the trustees of the trust to a more regulated environment with the beneficiary fund. So although the umbrella trust industry got a bit of a bad reputation as a result of what happened with the Living Hands situation, the reality is that if you can set up an umbrella trust with strong governance frameworks and strong administrative processes in place, there's no reason why an umbrella trust shouldn't be a very safe environment for money to be held. If we're going to use umbrella trusts in a retirement context, though, the umbrella trust must be nominated by the member to receive benefits from a retirement fund. And hopefully in the following slides, we will be able to unpack in what circumstances it may be a good idea for the member to nominate a trust arrangement in preference to perhaps a beneficiary fund or in combination with the two. David has spoken about what beneficiary funds are, so there's no need to go through those again. But I think the important thing, and this is where we talk about umbrella trusts in relation to individual trusts, is that both beneficiary funds and umbrella trusts have the opportunity to benefit from economies of scale. So they set up in a particular way to be administered within a fairly strict set of rules, and which means that the administrator is therefore capable of administering smaller settlements than what would be the case with individual trusts. So when we talk about financial planning and advising clients, the important question then becomes, what is the price that the client is willing to pay for individuality and the opportunity to have more flexibility in relation to the administration of the funds held in trust. David spoke about the taxation of beneficiary funds and the fact that once the benefits are taxed on the death of the member, there are no further tax consequences in the beneficiary fund itself. So benefits are received tax-free and there's no tax in the beneficiary fund itself. Trusts are not exactly the same, and we know that certainly in an estate planning context, trusts have been targeted, and umbrella trusts and potentially no exception to that particular rule. And so it is important when setting up these trusts that one does make sure that they are structured in a way that the rights of beneficiaries or the tax implications are not prejudicial to beneficiaries of those trusts. It is a trust, so the conduit principle applies. So what that simply means is that any income or gains that are earned by the trust are taxed in the hands of the beneficiary to the extent that they are distributed to that particular beneficiary during a particular year of assessment. In order to make sure that benefits are not retained in umbrella trusts and subject to punitive tax rates, umbrella trusts would typically be structured as vesting trusts, which means that all income and gains would vest in the beneficiary and any tax liability would be that of the beneficiary. Obviously subject to available exemptions, interest, for example, allowances and rebates. So if we look at smaller settlements for minor beneficiaries, often there are significant would be significant tax relief that those members would qualify for in relation to income and gains that are taxed in their hands. And obviously it would then be up to the trustee and the administrator of the umbrella trust to make sure that tax certificates are then passed on to those beneficiaries or to their caregivers during or at the end of the year, so that their tax affairs can be kept in order. So if we just look at the use and advantages and disadvantages of umbrella trusts versus beneficiary funds, an umbrella trust is useful in the sense that trusts themselves are somewhat more flexible in terms of the sources of funds that can go into trusts. So it has been said before that the flexibility of trusts is virtually unrivaled as an estate planning tool, and so we can receive funds into trust from a wide range of sources. Certainly in our line of business where we're involved with deceased estate administration, smaller trusts, we certainly do see umbrella trusts playing an important role, not only in receiving perhaps some slightly larger retirement amounts, but certainly to receive smaller amounts payable in respect of road accident fund claims, and possibly even smaller will trusts would probably be better managed in an umbrella trust type of arrangement than in a separate individual trust administered by a corporate trustee. The one thing that umbrella trusts do offer is that the member or establishing the settlement can determine the date on which the beneficiary becomes entitled to the trust capital. So that may be set at an age that is older than 18. So what is good then is that the trustee would then retain those funds in trust until the termination date, when the capital will then be, or the balance of the capital will then be paid to the beneficiary. As you said, the trust deed when it comes to trusts is critically important, and it is important to make sure that a reputable service provider is used with a strong governance framework regarding umbrella trusts to avoid some of the issues that we have been exposed to in the past. And perhaps a disadvantage is that the taxation of trusts is potentially more complex than with beneficiary funds. So I think beneficiary funds really do offer some advantages in that they're strictly regulated with an accountability to the FSCA. Once the money is in the fund, there are no further tax issues, but it is a little bit less flexible than trusts. So we may only receive employment-related benefits, and the default is to pay out at majority unless there would be reasons not to do so. So we're starting to see that where you perhaps have an amount that you would like to last definitely longer than the age of majority, an umbrella trust may be something that a member of a fund may wish to consider. So in summary, both beneficiary funds and umbrella trusts offer economies of scale. They're perhaps a bit more flexible, but they're less regulated and benefits may be taxable. And we've spoken there just about beneficiary funds and when they may apply. So how do we put this all together, and what are some guidelines that we could perhaps put in place to suggest when it may be appropriate to consider each of these? So certainly, if you have death benefits perhaps of less than an amount that you determine, let's say 1.5 million, and you've got fairly young beneficiaries, and it looks like that money is going to pay for their school fees, and there would be a reasonable amount left, but not too much for them to blow at the age of 18. A beneficiary fund certainly seems to be a very well regulated and tax-friendly kind of environment. Umbrella trusts could play an important role where you have smaller amounts and you've got other sources of funds. So certainly, as I say, what we do find in practice is that for good reasons, testators in wills will set up testamentary trusts to receive relatively small amounts. It might be a fund to pay for a staff member's child's education. It may be a small road accident fund, a trust for a minor beneficiary, and to administer that in an individual structure just doesn't make economic sense. In that regard, an umbrella trust would certainly be something that should be considered as an option or as an alternative. When amounts get larger, and certainly, with retirement amounts, so perhaps you have an amount perhaps greater than 1.5 million, perhaps approaching 2 or 2.5 million, and you do foresee that the money itself there's going to be a portion that will be left over to cover things like perhaps university education, perhaps until the age of 21, 23, or 25, then you may look to establish an individual trust. At that particular point, it becomes economically more viable to administer an individual structure. Certainly as financial advisors, there's probably the need for more financial advice in terms of the underlying selection of portfolios and funds, and certainly interaction between the trustee and the beneficiary. And certainly what we've also seen is that with larger amounts, the discussions about how to apply benefits where there are choices in relation to education may be well served by having an individual structure. The problem occurs where you have relatively small amounts. There's limited value that the trustee can really add because there's just not enough money. And what we then find is that the running costs for the trust tend to eat into the capital. So it ends up not really serving anybody at the end of the day. A road accident fund. So trusts have been a popular place into which to place large amounts from the road accident fund. And I think, I'm reminded of, David's point about, what to do when you win the lottery and to sit on the money for 6 months. Certainly, we've been administering RAF trusts for a long time, and the amount of money that can be paid to beneficiaries can be very large in relation to what they're used to, and they're not used to handling such large amounts of money. And so we can certainly add value in terms of applying some kind of guidance and oversight, which is really the protective nature of a trust in any event, to make sure that that money lasts as long as it possibly can, and that it's used for the right purposes. Again, if you have larger amounts, it's probably worth while to consider, an individual structure, because there is an opportunity to play some kind of a role in the application of benefits, because there's enough money to go around. But for smaller amounts, again, your beneficiary fund isn't going to work there, but an umbrella trust would be a great solution, because they're well geared to handle smaller settlements. So if we look at a financial planning roadmap, and we look at the three concepts that I've been talking about, certainly beneficiary funds are a highly regulated, great place for employment-related benefits, and certainly smaller amounts that will typically deplete or get to a point where there's an amount that's not excessive to be paid to the beneficiary at the age of 18. Between that and the individual trust, though, there is sort of a middle ground, and this is the role that the umbrella trusts can really play in providing an opportunity for funds to be protected, but also in an environment where the administration costs are not going to deplete the funds held in trust. So certainly for larger amounts where you're looking at potentially university education, the idea is to keep the money. It's not limited to employment-related benefits, so smaller will trusts, RAFs, trusts, etc. Umbrella trusts really become a very attractive solution for that. And then, as I've said, larger employment-related benefits to last until older than 18. And then individual trusts, again, as you get sort of beyond sort of the 2 million rand mark, individual trusts can play an important role. Again, the source of funds is not limited, and individual trusts can be used for estate planning, wills, and for RAF claims. They are fundamentally more complex. Certainly, when we get to the world of estate planning, there are many considerations in relation to trusts that would need to be taken into account. But certainly, even in the environment that we're talking to, so if you're talking to retirement fund members and they are likely to receive large amounts, an individual trust may be something to consider. And as I say, there are different rules that one can put in place, but certainly in what we've seen, I've certainly found that we're able to add most value where the amounts probably exceed 2 million. And that's also an environment where I think the assets justify the need for individualized financial advice and some flexibility in terms of the application of benefits. It is important to note, though, that if you are going to look at trusts, the member himself must nominate the trust to receive benefits. The pension fund trustees won't automatically pay to those environments. Just to talk about the Momentum Umbrella Trust, just to kind of bring it closer to the Fairheads environment. So David spent a lot of time talking about the administration of the Fairheads Beneficiary Fund, and Fairheads administered the Momentum Beneficiary Fund as well. And so when we identified this need, that fitted somewhere between beneficiary funds and individual trusts, we decided to partner with Fairheads for that, for the simple reason that we've created something that is an umbrella vesting trust, but it's designed to mirror the normal Fairheads beneficiary fund, and so the services and administration that's provided in relation to this is very similar to what clients may experience from the beneficiary fund. So for financial advisors, it's actually more a case of deciding what the vehicle is and not really having to learn too many different rules regarding how each of them works together. The governance framework is a very strong one. David spent a lot of time talking about how they go about ensuring a strong governance framework for the beneficiary funds. That's required by law, but they apply exactly the same principles to their umbrella trusts. And it certainly fits an important gap that exists in the market, and something that I certainly think warrants more attention. And that covers what I wanted to talk about today. So from my side, just to thank you for your attendance and for your participation, and over to you, Gareth.
Thanks, Jeffrey. I really enjoyed that presentation, and I like the way you brought some relevant points for financial advisors and financial planners into the mix there. There are a couple of questions which I thought we could quickly address since you have a bit of extra time on your half hour here. One comes from Anonymous, who's really asking you to just comment a bit more on the impact of fees on the capital amounts in, I guess, a beneficiary fund. Is it fair? I mean, you did speak about costs quite a bit. Is it fair to assume that the cost sort of goes up from a beneficiary fund to an umbrella trust to a individual trust?
So it's a difficult one to answer in the sense that, so yeah, let me start with this. So the role of the trustee is fundamentally a protective role. So it's difficult. So one shouldn't view the trustee costs as an investment related charge, but the practice is for people to do that in general. And so what one needs to do is to look at your costs of administration, your costs of the beneficiary fund itself, and certain of the other costs. So what you'll find is that the beneficiary fund might charge what looks like a slightly higher percentage, but it will generally be on smaller amounts. What the individual trustee will have to do is that he will normally have to pay an accountant to do annual financial statements for the trust will be charged as an individual charge against the trust. Where you take an umbrella trust, what you would do is you would perform an annual audit for the whole umbrella trust and then divide those costs across the different individual settlements. So essentially, the umbrella trusts are set up from a cost point of view to be very cost effective for smaller settlements. As you get to larger amounts, you might be able to charge a slightly lower percentage, but it'll normally be on a bigger amount, and there may be other role players like financial advisors and accountants that would tend to then start to eat into the capital of the trust. I'm not sure whether that answers the question adequately, Gareth.
Yeah, I think that's a fair stab at it. A question from Jill Foe, who's asking specifically about testamentary trusts for a disabled child in this case, is asking whether the guardian in that matter would have access to the investments and expenses in that fund. Now, I'm not sure if she means whether they'll be able to. I think the next question was whether the guardian could request financial support. So perhaps just what a guardian might or might not do in a testamentary trust.
Yeah, so maybe what I can explain there is how we would apply it in an individual situation. So we would receive an amount into the trust, typically as a trustee. We would normally then get some kind of an income and expenditure account, bearing in mind that the trust is set up for the benefit of the beneficiary. And we would then make distributions based on what we understand the beneficiary's maintenance requirements to be. And we would be quite careful to link the payment of benefits to the needs of the particular beneficiary concerned, although the physical payment of money would maybe to the beneficiary. Certainly for larger amounts where we would be asked to pay, for example, school fees annually in advance, we would typically pay the service provider. So the guardian would have limited access to that, but typically your monthly distributions would be made directly to the guardian. There are some grey areas where, for example, you might have a minor beneficiary that would be living with an aunt or an uncle, and there may be some need to contribute towards household costs, but that would be viewed by us as a trustee in the context of the protective role that the guardian plays in relation to that minor beneficiary, and not as an amount to benefit the guardian directly. So it always comes back to making sure the benefits held in trust are applied specifically to cover the maintenance of the beneficiary.
Thank you, great answer. I think we'll leave any further questions to the end of proceedings. I want to move along with the next. So thanks, Jeffrey Wiseman, for that presentation. Our final presentation for the day or for the morning is from Shamir Chothia, who is an employee benefits and legal consultant at Momentum Corporate. He's quite timely discussion this, which is on the legal implications of divorce settlements and maintenance awards on retirement fund benefits. I think anyone watching the news today will have seen that Bill and Melinda Gates have announced that they will be parting ways after, I think it's more than a quarter century of marriage. Anyway, Shamir, if you could take it away for us, please.
Thanks, Gareth, and morning to everyone. It's great to be part of this great session. Like Gareth mentioned, my name is Shamir Chothia. I'm going to talk through some of the retirement benefits and the impact from a divorce and maintenance perspective. Majority of the presentation will probably be focused on the divorce aspect, but I will touch on the maintenance aspects as and when necessary. So just a quick agenda. Sorry, Gareth, is my screen sharing?
Not as yet.
Sorry about that.
That looks good now, thank you.
Yeah, sorry about that, everyone. So on the agenda, we're just going to quickly set the scene, get some general background around divorce, impact, and those types of things. We'll touch on some of the legal requirements. We'll then look at what can go wrong and what often does go wrong, and then how you as a financial advisor can play such an important role to your clients in this specific instance, and some of the things to keep in mind. So just setting the scene, I mean, the reality of divorce is, I mean, it's not something one can actually prepare themselves for. Often when it does happen, it becomes a very painful and a traumatic experience. Most of the time, it's often the physical and the emotional well-being that's taken into account. But during that whole process, people tend to forget that there will also be a financial impact which needs to be factored in, which needs to be catered for in one way or another. So that already is, for me, the first important point, is that while it is a very personal and traumatic time from that perspective, one needs to also keep their wits about them and make sure that the financial aspects are also looked at and taken care of, obviously for the purpose of their lives going forward post the divorce. An important part of any divorce, if there is any children involved, custody of children plays a big role, but maintenance in general, it could be maintenance of a spouse, it could be maintenance of a spouse and children. That's a big part of any divorce proceedings, and it is linked to your retirement savings, but I'll touch on that a little later on. Another one of the impacts is definitely an expected drop in the standard of living. It could be for both parties, could be for just one of the parties, just depends on the circumstances, but that's something that's very important to take into account, and something to be able to be kept in mind so that one can plan accordingly to ensure that there isn't a significant drop in your standard of living. And then probably the biggest part of any divorce proceedings is the discussions around the splitting of assets. And I mean, you very seldom get the case where this goes quite smoothly. In most cases, I assume it's a lot of disagreement, a lot of tension when these discussions come about. And the settlement agreement between the parties, which often forms part of the divorce order, that's such an important document where everything needs to be properly detailed. And often we find retirement assets is not something that's automatically thought of. I think in some cases it's just a matter of not knowing. In other cases it could be just maybe forgetting about it. But retirement savings and retirement assets can play a big role in terms of the settlement agreement and determining how a portion of that could be allocated to a non-member spouse during certain proceedings. So that's important, and a lot of the discussion is going to be around that and what needs to be in an order and those types of things. So just some interesting facts which we found. Statistics for 2019, this is from Stats SA. There were more than 129,000 marriages in that period, of which 23,000 resulted in divorces, or let's rather put it in a way that there was also 23,000 divorces for that year. So almost 1 in 5, 1 in 6 marriages ending in divorce. Globally, South Africa ranks almost in the middle, so maybe not as good or not as bad, but it's not something to easily judge or put your hand on certain things to say it's because of this or that. So that's something to keep in mind. I mean, obviously, it plays a role in terms of from a statistical perspective. And then very interestingly, in the last year, obviously during the lockdown which we experienced, we found that there was a 20% increase in the rate of divorce during that period. For obvious reasons, maybe it became too much working from home, but I mean, that's just a little bit of a sarcastic remark, but I mean, it could be many reasons as to why that's the case, but that also is an alarming thing to keep in mind. And then in terms of length of marriage, what the stats is showing us is that 4 out of 10 marriages end in divorce before their 10th anniversary. And basically most marriages that do end in divorce last between 5 and 9 years. Now, again, it's just numbers. I mean, obviously each case is different, but it's, again, it almost paints a picture of just very short periods before it goes down that road. So, and then for those of us who are lucky enough to probably married for more than 35 years, I mean, the stats show that those types of marriages often don't end up in divorce. But again, I mean, on paper, it's just a matter of stats, but quite interesting when you go through those types of things. So a big part of any divorce proceedings comes down to assets, liabilities, like I said previously, maintenance maybe, but how are the assets split during a divorce? Again, linked to my previous slide, your settlement agreement will have a lot of the information in there. It's a key part of your divorce order. And it's important that the retirement fund assets be properly detailed in there, following the formal requirements, which I'll go through later on, to ensure that the order is effective from the first day that you send it to the fund, without then having to later on have to go back to court to amend wording and those types of things. So splitting of assets, it's important to always understand from day one, maybe get in touch with your fund administrator or your fund legal team and let them give you a sense of what would be considered acceptable wording. I mean, we've done this for a lot of clients. It saves them a lot of time and additional up and back and forward having to amend orders. So if you get it right from day one, the process can work a lot quicker. But obviously in practice, we find more often than not, initially divorce orders come in without the formal requirements being met. And then the biggest part for you as financial advisors is how does it impact on either of the members' journey to a successful retirement, but overall, how does it impact their total financial planning, estate planning, all those types of things. And that is such an, again, brings back the importance and the essence of a financial advisor and what they can offer to you. And that's such a big role, which again, most parties tend to, I won't say forget, but often neglect. And that's a very big consideration because it does impact the way you will go about doing things compared to how you had planned to go about doing things pre the divorce. So looking at the legal requirements, so the actual legal requirements I'll summarize in one of the latest slides, but just some of the things to keep in mind which are important is retirement assets or retirement savings are part of marital assets, but obviously it does depend on what type of marriage you have concluded, and I'll talk to that a little bit later on. So that's the first important point, is that it can form part of marital assets, it can form part of your settlement agreement, and it can be included in the divorce proceedings. From a legal perspective, obviously it must be a legal marriage in terms of the Marriages Act, and it cannot be the so-called common law marriage, or let's say universal relationship, where it's people just living together and not formally married. So in those instances, it probably wouldn't apply. And then, like I mentioned earlier, if you are married in community of property or married out of community of property with the accrual system, then your retirement assets certainly does form part of your total assets during those divorce proceedings. And it's important that you keep that in mind. For people who are married out of community of property, then it's clear the assets will not form part of those discussions. But that's already the first port of call, is to determine what type of marriage are you in and whether or not it will form part of the assets or not. Then relating to the pension interest, which is what is claimed from the non-member spouse from the member's retirement savings, it comes down to different positions being applicable to different types of funds. So if we look at occupational or umbrella funds, it's often considered to be the amount that the member would have received if they had resigned on the date of divorce. So that's an important one, quite an easy calculation in that sense. And with regard to preservation funds, fairly similar. It's the member's withdrawal benefit on the date of divorce. But when it comes to retirement annuities, a bit of a deviation in terms of how that pension interest is calculated, in that it's all the members' contributions up until the date of divorce, plus simple interest. And simple interest is linked to the prescribed rate of interest, which is a legislative thing. It's obviously reviewed as and when, and it's linked to that specific interest rate. So it's not necessarily members' contributions plus full fund return, but it's within that framework of contributions plus simple interest. There is some calculations to be done before determining the actual amount of pension interest. So that's slight deviation to keep in mind, but it's fairly important in determining how you go about wording your settlement agreement and your divorce order. So again, a perception in the industry is that in most cases, pension interest is often just given as 50% of the member's pension interest, and that's what you find in majority of orders, but it doesn't necessarily have to be the case. It can be anywhere between 0.1% to 100% of pension interest. It's totally up to the parties to determine or to agree on what percentage of pension interest they are looking to claim, and that is what should be stated in the divorce order. So that's important to keep in mind. But again, very importantly, agreement between the parties. But like I say, majority of orders that we find is often 50% of pension interest. And then another important tool, which again, with the guidance of a financial advisor can obviously play a big role, is that maybe again, between the parties, they could agree that pension interest not be claimed, maybe by offsetting, by letting certain other assets be given away instead of touching the members' retirement savings. That's purely, again, between the parties to agree on. It's not a matter of you have to attach the pension interest. The settlement agreement will again detail that, and that will then determine the way the claim should be put forward. So it's important to keep that option in mind so that parties can also consider that as an alternative if there is a way to find agreement on that. Any benefit that's allocated to the non-member spouse is done so from the date of divorce. any interest or fund return which is payable to the non-member spouse is up until the date of divorce. It cannot be in relation to any benefit that's accrued or built up after the date of divorce. So that's important as well. It's only in relation to that. There have been pension fund adjudicator cases confirming that. And that's also another thing which is often sometimes misinterpreted into believing that it's the member's full fund benefit and not just up until the date of divorce. So that's important to keep in mind. And then lastly, post the clean break principle, non-member spouse is responsible for the tax on the pension interest. So depending on the type of benefit the non-member spouse chooses to take, either by way of a lump sum, they will then be responsible for the tax. If they choose to transfer to another fund, then it will be tax-free because it's a transfer from one fund to another. So importantly, the non-member spouse is responsible for the tax on their portion of the benefit. So then just looking at some of the timelines in respect of a divorce order. So from within 45 days of the fund receiving a valid and binding divorce order, they have to go back to the non-member spouse and request the non-member spouse to make an election of how they want the benefit to be paid. The non-member spouse then has up to 120 days within which to make that election. If they make an election within that 120 days, and the election being either to take it as a lump sum or to transfer it to another fund, if they make the election within the 120 days, the fund then has 60 days within which to give effect to that payment. If the expiry of the 120 days goes by and we've not received an election from the non-member spouse, then the fund has a duty to pay the benefit directly to the non-member spouse if they have the non-member spouse's details to effect that payment. And that must be done within 30 days of the expiry of that 120 days election period. And then lastly, obviously, if the fund doesn't have the details to effect the payment, the benefit will remain in the fund until such time that they receive the payment details. And again, we've seen a trend of late that maybe it's just a matter of certain instances where non-member spouses forget, or maybe maybe just forget about providing it. But we've seen a lot of cases where benefits are retained in the fund purely because banking details are not provided. And that's an important thing. And when you work directly with an advisor will keep you to that, to ensure you to keep track of things and to help. So I always emphasize to clients that working with an advisor certainly smoothens the process and certainly helps the fund to also give effect to these orders a lot easier and a lot quicker. So just looking at some of the historical aspects relating to divorce and retirement funds. So previously, a non-member spouse could not claim payment from the retirement fund immediately. They had to wait until the benefit accrues to the member by way of the member leaving the retirement fund. So even though your divorce order could be now, you had to wait until the member either resigns or retires from the fund. Then in 2007, the clean break principle came into play. And what that did now, it removed that requirement to wait until the member leaves the fund. And it now allows a non-member spouse to provide an order to the fund and receive payment of the benefit immediately once the order has been given effect to. So, and that is then also now why the non-member spouse is responsible for the tax on the benefit. So that's an important change which happened. I mean, it's been quite a few years now that it's applied, so it's fairly accepted now. You don't see many orders where it related to pre-2007, but previously you would have to say that the records be endorsed so that at the time that the member leaves the fund, obviously the administrator has to give effect to the divorce order. Whereas now there's slightly a different way of approaching the wording, but I'll talk to that when I go through the final requirements. This does apply to all retirement funds, pension, provident, retirement, annuity, and preservation funds. And like I mentioned previously, a non-member spouse has a choice to take either a lump sum benefit or transfer to another retirement fund. So these for me are the most important aspects or requirements for any divorce order. Number one, it must be granted under Section 7(8) of the Divorce Act. The client must be a member of the fund at the date of the divorce order. That's such an important one. And then the fund must be named or identifiable from the fund. This often, depending, I mean, we have instances where members have, for example, if I use Momentum in this instance, they may have a Momentum retirement annuity, they may have a Momentum employee benefits savings as well. And often the wording is not clear enough or wide enough to determine, is it relating to the pension fund? Is it relating to a retirement annuity? So it's important to take into account all the different retirement savings that are applicable to make sure you name the fund clearly, or at least let it be identifiable either by way of a member number or ID number or something of that sort, depending on the circumstances. And that's a very important part of any divorce order. Then another important one is to always specify the amount of pension interest that is to be deducted. So either 50% or 100% or 80%, whatever it may be. You can also specify a rand amount. We've seen some of those coming through, but it's important that it states that it's a percentage or a specific amount of pension interest. Those words are very important. And then lastly, linked to my previous slide, it must not just state that the fund must make an endorsement in its records. It must be clear from the order that the fund is ordered to pay the benefit to the non-member spouse. Without an order to pay, the fund cannot give effect to that order. So these are the key aspects relating to the divorce orders. If I just quickly tie it up to maintenance orders, fairly similar in that the fund must be named or identifiable. The amount of maintenance must be stated in the order. So, I mean, it's often that the court itself determines what is deemed to be the amount of maintenance. They consider certain factors. It's not the fund that determines the amount of maintenance that needs to be deducted. And the order must also be clear in whether the amount is in respect of future maintenance or is it in respect of arrear maintenance. So those are important things. And again, the fund must be ordered to pay such maintenance across. So that's important to keep in mind. So looking at what can go wrong and what often does go wrong, I mean, the most common thing is poorly drafted divorce orders. While attorneys may be very familiar with the standard legalities, it's often they look past or are not aware of the specific requirements that are needed within a divorce order. And we often then find divorce orders having to be amended sometimes 2 and 3 times, dragging out the process, costing the member money. So it's important to always, from day one, like I mentioned previously, try and get in touch with the specific fund administrator or legal team and get a sense of what would be considered as acceptable wording so that you don't have those types of instances. And then you find a lot of divorce orders where the standard requirements or the most important requirements are not in the divorce order, specifically fund ordered to pay. You get a lot of them where it just again states the old wording of make an endorsement, but there's no clear instruction for the fund or order for the fund to pay the benefit across. Division of pension interest, sometimes there's different wording used, maybe pension fund interest or provident fund interest. That will obviously differ from fund to fund in terms of the way they interpret the order, but it's important for funds and trustees to also have their own guidelines in terms of what is acceptable to them and what not in terms of the gray areas that presents themselves. For me, this is probably the part that impacts all of you as financial advisors the most. And I think this is where you guys can create a lot of value for both parties related to the divorce. I mean, if you work with them as a couple, it's important that you make a decision whether you continue to work with them individually or work with only one of them. But it's important to also try and get in touch with other professionals early in the process. For example, a divorce lawyer. so that when you're working with a divorce order and making sure the requirements are met from day one, you can ensure that the order is drafted in such a way that it meets the requirements of the fund for it to be a binding and valid divorce order. So collaboration is important. Objectivity and impartiality, I mean, that goes without say for any financial advisor, not only in this instance, but that again remains important considering now the dynamics between the two parties. There's obviously pre-divorce and post-divorce where certain things need to be looked at. I mean, for example, during the divorce process, certain expenses that may now become applicable that maybe they didn't have previously. The element of maintenance and how does that build into their overall financial plan going forward. Looking at your standard assets and liabilities, looking at policies that may be in place, maybe updating of beneficiary nominations, considering now that a divorce is ongoing. We find a lot of cases where members are divorced, and when they pass away, you still find the ex-spouse listed as a beneficiary. So that's quite an important thing. I mean, again, often overlooked, but keep your will up to date. So there's a lot of touch points for an advisor to interact with their client and help them to get geared towards moving forward from this specific divorce, and to try and make their future financial planning a lot more smoother and not a bumpy road. Obviously, importantly is what to do with the pension interest, the tax implications, if they do have other retirement funds. I mean, the option of transferring to another retirement fund tax-free plays a big role. So that's important. And then after the process is finalized, again, comes down to the overall financial planning. The bigger picture now is to obviously look at it in context post the divorce, and to ensure that they continue to fulfill the obligations of the divorce settlement. Proper estate planning, again, emphasis on updating beneficiaries, those types of things. And there's a lot of value which can still be created after the whole process is done. And I think that's where members and non-member spouses need to look to pay more attention to, is to engage the correct advisors, work with them, not only to get the order in place, but also to get lots of further financial plans in place after that, to ensure that they still well taken care of afterwards. That's it from my side. Thanks for your time, and we can take any questions.
Thanks, Shamir. I enjoyed that. Certainly quite a number of questions streaming in, which indicates how technical this area of financial planning and retirement fund administration can be.
Yeah.
What I thought we would do is I'll start with a few of the questions on specifically on divorce benefits.
Okay.
So the first anonymous attendee asks, if you are married ANC without accrual, are you safe from the splitting of your assets in a divorce?
Yeah, so I think that's exactly the case. If it's pure antenuptial contract without accrual, the assets doesn't form part of the divorce. And yeah.
The second question looks at Muslim divorces, and it's asking whether they are dealt with in respect of a pension interest on non-civil divorce. Apparently there was a PFA ruling that Muslim divorces or divorce orders should be considered for pension interest.
Yeah.
What are your thoughts on this? The person refers specifically here to things not tying in with Section 7(8) of the Divorce Act.
Yeah, so I do recall the specific case, and there was the matter of it not being exactly tying up with the Divorce Act in terms of, like you say, Section 7(8), but it is now considered in terms of like you say, through the pension fund adjudicator matters, that it should be considered for pension interest. I'm sure we'll see some of this coming through in proposed legislation, where they're looking to almost create one central Marriages Act that almost encompasses everything. So I think it definitely does apply now, yes.
Yeah. Another viewer, Quibus Chalmers, asks, what if the prenuptial contract specifies the pension funds must be excluded on divorce? If the client is married in this case, out of community of property with accrual?
I think, again, it probably comes down to the agreement between the parties. If they've signed that up front, it's obviously with consensus between them. So I assume at the time of coming up with a settlement agreement, the same provisions will continue to apply. And like I say, it's agreement between the parties that's important. It's not you have to do it in a specific way. So that's an important part to keep in mind.
So the audience is really putting you to the test here today. I've got quite a few, but luckily they're fairly short and simple to answer. Asking, will the calculation start date be the date of marriage? If the marriage was after the inception of the pension fund? Sorry, so I'm thinking if the pension fund already exists and then the person gets married, does that apportionment happen from the date of the marriage or from the date of the inception of the fund?
Well, it depends what's stated in the order. And again, it's one of the gray areas. So it depends on what that specific fund deems it to be. So we have seen orders where it says from date of marriage to date of divorce. And then in most instances, it's not written in that way. It's just written generically, where it then applies from the member's full membership within the fund up until the date of divorce.
Okay, I'll ask you one more question and then I'll bring Jeffrey in, perhaps if he's still on the call. So somebody else asks, in the case of a living annuity income stream, does this now also become an asset in the divorce proceedings?
Yeah, so that's an interesting one. I know there was some case law on that in the last year or two where there was discussions around that. I don't want to say yes or no without fully being confident on that one, but I do recall there being case law. It won't be in terms of the Pension Funds Act because living annuities are dealt with outside of that. But I think there was some decision where there was scope for it to be considered, but I can certainly look into that one and provide feedback to the person who asked the question.
Okay, great. Jeffrey, are you still with us?
I am, Gareth.
Great, thanks. I thought there were still a couple of questions that are more trust and beneficiary fund focused. A question from Lucy Seguapa, who asks, in terms of regulation on section 37 about the distribution of funds, how would funds be distributed between the spouses and the children in terms of the percentage? And she mentioned here, especially to the remaining spouses. I'm assuming this is more like, well, perhaps you can address.
It's probably a pension fund trustee type of question, and I think the answer to it is that it differs, and it obviously is based on level of need. I certainly know that, and again, not my sort of topic for today, but in an involvement that I have had in being a trustee of pension funds, there was a policy document that the trustees had that they would look at representation from potential dependents and would determine how then to apply benefits in order to achieve an equitable outcome. Shamia, you may be closer to the allocation of benefits in terms of section 37C at the moment.
Yeah, I think your answer is almost spot on, Jeffrey. I mean, each case will differ from facts. I mean, it does depend on the level of dependency, and that forms part of the investigation which the trustees do. I mean, so it's difficult to just give a clear answer to say it will be in a specific way, but it forms part of the investigation, and each case will differ from case to case.
Okay, great. We have another question on the beneficiary funds side of things, and they ask, are the funds limited to employment-related benefits only? What about payments made in terms of section 37C2 in respect of RA death benefits, for example?
Amir, do you want to take that? Big pardon, or me?
Jeffrey, if you could start and then
Shamir can finish up. So this would probably be sort of a David question he would, to answer, but unfortunately he's not here. my understanding is that any employment-related benefit, which at one stage I think was quite narrow, but it certainly has been widened up. So I think in one of David's slides he talks about sort of unapproved group life benefits. So I would imagine that anything that would be sort of employment related and or pension fund organization related would probably qualify then to be paid into a beneficiary fund. Shamir, do you have a similar view, or is yours different?
Yeah, no, I agree. Again, from my previous history working in the retail space with retirement annuities, we certainly did make use of beneficiary funds. Maybe not as much as we do in the employment space, but certainly it was an option that was on the table.
Okay, we've got a couple of more fairly technical sounding questions here, but maybe Shamir can have a stab. An anonymous attendee asks, if you're married in community of property and your spouse moves overseas and has a pension fund benefit accruing there, would the South African spouse have any rights to that fund following a divorce? I mean, this is a cross legislation type of matter. I don't know if you can even address it.
That's a tough one. I've not specifically dealt with, but I would just thinking about legalities, I would expect the foreign law to also play its part in determining whether it's included or not. So it's a difficult one for me to answer off the top, but again, happy to provide it on email response.
Sure, 100%. There's been a few questions on the sort of customary law and the impact of customary law on divorce. Are you able to offer some insights on that?
Again, not specifically dealing much with it, but I think let's leave that for email discussion as well, if possible.
Okay, great. And then, I mean, maybe not to draw this on too long, perhaps we'll just end with this final one from Edward McQuena, who asks, if you are married in community of property and both partners have a retirement fund, how would the split actually work? Do they go 50-50 on each fund, or does it really just get thrashed out in a court of law?
Yeah, so it's probably again down to the agreement between the parties. I mean, if it ends up being a neutral effect, then it doesn't make any sense in that I claim yours, you claim mine, but we almost a zero-sum game after that. So it's all down to the agreement. It's all down to the settlement agreement. If it's a neutral impact, then it may be that they decide to give other assets or those types of things. But everything comes down to the agreement between the parties. There's no fixed. I mean, the court also won't just determine the pension interest. It must be some sort of agreement between the parties before that.
Thanks very much for that. Jeffrey, I thought I'd ask a closing question to you, something that I was thinking about during your presentation, which is really, how do you actually interact with financial advisors from your perspective? How does the brand interact with financial advisors?
Yeah, so that thanks, Gareth. I think it's a good question. And from our point of view, Momentum being an intermediary, so most of our business does come to us through financial advisor referrals. So they're a very important part of our network when it comes to offering fiduciary services. So in a trust arrangement, and this is where, perhaps, your individual trust, there would normally be a financial advisor linked to the client. We would be aware of who that financial advisor is. And then if it does become a trust, we would structure it on the basis that we would provide the trust and trustee administration, and we would then appoint the financial advisor to be the financial advisor to the trust. Obviously, we do have legal and fiduciary duties, and sometimes there is conflict, but we would generally do what we can within what is permissible to protect that relationship and to ensure that the financial advisor does have a continued relationship then both with the trust assets and then also as the primary contact between that family and ourselves.
Great, thanks for that. One final question for you, Shamir, and then I think we'll call it a wrap. Can a divorce order be amended? In other words, you get a divorce order and you find that there's a problem in it. What can be done to remedy that?
Yeah, so I mean, we've seen that in a lot of cases. You have to then go back to court and have the order amended. So it's a process and can end up being costly if you don't get it right the first time, but it definitely can be amended, yeah.
Well, gentlemen, thank you very much for that. I know we're a little bit early from where we were hoping to be at the end, but I think we've pretty much covered a broad spectrum of questions. And as we mentioned during proceedings, we are more than happy to do some written Q&A and get back to all the attendees here. Perhaps if you'd like 30 seconds each to offer some parting thoughts. It's not mandatory, but I'm sure the audience would enjoy. Shamir, if you'd like to go.
Yeah, sure. I just want to say thanks. I think it was a great opportunity. A lot of good questions coming out of it, and certainly we'll look to getting to those and providing the feedback. Thanks for your time.
Thanks very much, Shamir. And Jeffrey, over to you for a parting thought.
Yeah, just also from my side, just to thank you very much for the opportunity. And I hope that the information that we shared has been of some benefit to you, and that after the presentation, you will have perhaps an understanding of, how the different solutions can play a role in enabling your clients to meet their financial planning needs.
Great stuff. So some parting words then from my side is just to thank each of the presenters today, to David, who has unfortunately had to leave the call early, but also to Shamir and to Jeffrey. And also a special word of thanks from FAnews to the support from Fairheads Benefit Services and from Momentum Corporate. It's fantastic to have you guys on board to make this live webinar possible. And finally, to all of our listeners, viewers, our audience, our attendees, whatever we call them these days, thanks guys for attending, and thank you very much for being so interactive. I mean, it really helps to have a steady stream of questions coming in, and leaves the host of the show not having to think too much about what questions to pose to the guys. Thank you very much. I think we'll call that a wrap. Thank you, everybody.
Thanks, everyone.
Thank you.